My name is Jed McKeon, and today we're going to talk about the difference between jail and prison. Now, like the terms attorney and lawyer, these are two terms that get thrown around a lot and are thought to be interchangeable. They're actually very different. When you get arrested, you're out on the street and you're charged with committing a crime, you are taken to jail, not prison. Every county in Tennessee has a jail, and that is where people stay generally for short periods of time or they are awaiting a court date coming up. People who are there, usually if they're serving a sentence, it is less than a year-long sentence. Now, if someone is in prison, there are only a few prisons across the state of Tennessee, and someone who is serving time in prison has already been found guilty or pled guilty and are serving a longer sentence generally for a longer period of time, more than 1 year. Prisons are generally actually nicer than jails. They are designed to rehabilitate people. Jails are usually overcrowded, and that is not generally the case in prisons.
There are key differences between a misdemeanor and a felony. In layman's terms, a misdemeanor is a minor criminal offense, while a felony is a much more serious criminal offense. But the fundamental difference in our justice system between a misdemeanor and a felony is that felonies and only felonies could land you in state prison. A misdemeanor carries with it a maximum sentence of up to a year in county jail and a $1,000 fine. By contrast, a felony carries with it up to a $10,000 fine and up to life in prison or even the death sentence for a special circumstance murder.
It is common for the general public to misunderstand the terms probation and parole. Probation and parole are two different concepts, but are based on the same concept. Probation is an optional sentence a judge may assign, and rather than the person going to jail, they are sentenced to probation. Probation is usually assigned in cases involving misdemeanors or first-time nonviolent offenders. If a defendant is sentenced to probation, they could be required to do a drug test, pay several fines and court costs, and perform community service, counseling, and more. On the other hand, parole occurs once a defendant has already served some time in a correctional facility and requests an early release dependent upon certain conditions that must be met in order for them to remain out of prison. If these conditions aren't followed, the defendant's parole could be revoked and they could go back to prison. Just like probation, if the terms of parole are completed successfully, the case is terminated.
So you know you want a lawyer, but looking at the sign it says barrister and solicitor. Well, what's the difference? This comes from Old English tradition, where there was a separation between the work of a barrister and a solicitor. You would first of all hire a solicitor who would put the case together, do the research, then that person would hire a barrister and the barrister goes to court. So the primary difference is a barrister is a courtroom lawyer and a solicitor does the background research and paperwork. But in British Columbia, all lawyers are allowed to be barristers and solicitors. That doesn't mean that they may not specialize in just doing court work or just doing solicitor work, but they're allowed to be both. That's what it means. Indeed, all barristers and solicitors in British Columbia are also notary publics. So you can bring documents to a lawyer and have them notarized, and they can do things like document preparation, wills, and that sort of thing that notaries often do.